Okay, great. And then can you see the PowerPoint on your screen still?
Yes, we can.
Okay, great. All right. Well, my name is Jenna Russo. Happy to be here today. I'm with the law firm of Running Lewis and Lacey, and I'll be providing a 1 hour open meetings law training. We'll talk about a variety of subjects today, including the public policy supporting the open meetings law. We'll talk about what a governmental body is, what is a meeting. We'll talk about notice requirements. We'll talk about open session requirements, closed session requirements. We'll talk about some of the closed session exemptions, and we'll focus on the ones that you're more likely to use than others. And then at the end, we'll talk about enforcement and consequences when the open meetings law is not followed. So let's start with public policy behind the open meetings law. The public policy behind the open meetings law supports transparency. Transparency is the key to an informed electorate. So the open meetings law stresses that meetings must be open to the public and they must be accessible to the public. Along those lines, closed sessions are only permitted when an open session would be incompatible with the conduct of governmental affairs. In other words, a specific exemption must apply. You have to comply with the parameters of those closed session exemptions. Closed session exemptions cannot be used for convenience, etc. We'll talk a lot more about that when we get to that section. But in general, the open meetings law stresses transparency, openness, accessibility, etc. The open meetings law is also liberally construed when being interpreted again for openness and transparency. Turning to what is a governmental body? Oops. A governmental body is defined broadly. It's a state or local agency, a board, commissions, department or public body, corporate and politic, created by constitution, statute, ordinance, rule, or order, and then it continues on. When we're looking at what is a governmental body, the key questions are how was it created and what is its function? Again, this is interpreted very broadly. So when we're looking at rule or order, this could mean anything such as a curriculum committee established by a school district. If it's created by a school board rule and the committee is given authority to select educational materials, and that's just an example. But when we're looking at what is a governmental body, certainly the town board is any committee established by the town board. And if the town board establishes any other body by rule or order, by ordinance, those are all things that would likely constitute a governmental body. And that governmental body would need to comply with the open meetings law, like the town board would. Turning to what is a meeting? A meeting is the convening of members of a governmental body for the purpose of exercising responsibilities, authority, powers, or duties delegated to or vested in the body. When we're looking at determining what constitutes a meeting, the courts have issued decisions in this regard and implemented the Showers test you'll see on your screen. There are two questions when we are applying the Showers test. The first part of the Showers test focuses on the purpose for which the members of the governmental body are gathered. More specifically, they must be gathered to conduct governmental business. Governmental business is also defined broadly. It refers to any formal or informal action, including discussion, decision, or information gathering on matters within the governmental body's realm of authority. So that is the first part of the Showers test. The second part of the Showers test focuses on the number of members present, and specifically, the Showers test requires that the number of members present be sufficient to determine the governmental body's course of action on the business under consideration. In this regard, a gathering of 1/2 of the members of a body, or even fewer, may be enough to control a course of action if it is enough to block a proposal. This is commonly referred to as a negative quorum. So again, the second part of the Showers test is how many members of the body are present. And is it one half? If it's one half or more, there's a presumption that they are there to be conducting a meeting. Even if they're less than half, we still could run into issues as far as having too many people present because it may constitute a negative quorum and it may be enough people to block a proposal. So again, Shower's test, when we're looking at whether there is a meeting, is the purpose to conduct governmental business, and do we have enough people there to determine the course of action the body will take? Meetings include not just in person, in today's world, video conference, telephone, virtual meetings are far more common. Any interactive forum, observing other meetings, if within the granted authority of the body, and also walking quorums. Those are all things that may constitute a meeting. Walking quorums are sequential contacts that form a consensus. In other words, the requirements of the open meetings law cannot be circumvented by using an agent or a surrogate to pull a quorum of members of the governmental body through a series of individual contacts. So again, that would constitute a walking quorum where multiple contacts are made for the purpose of arriving at a decision of the governmental body. Walking quorums constitute a meeting and would have to be noticed. Typically, one-way written communications are permissible unless it becomes a back and forth exchange. So if you do have a situation where, let's say you receive an update each week from an administrator who provides a report, and there is not back and forth exchange of information regarding business that's before the governmental body, that one-way communication is probably not going to constitute a meeting. However, where you may run into trouble is if there are multiple exchanges back and forth, like instant messaging or emails, where it looks like now we are engaging in governmental business and it starts to look kind of like a walking quorum that we talked about. There are certain types of gatherings that are not going to constitute a meeting. We talked about one-way written communications. The other is social or chance gatherings that are not intended to circumvent the requirements of the open meetings law. So a couple of you run into each other out in public. Maybe you're all at the grocery store at the same time. If the purpose is not to conduct governmental business and you're merely running into each other by chance, those are not situations that are going to constitute a meeting. And as I mentioned, there is a presumption that if one half or more of the members of the body are present, it is presumed to be a meeting. That presumption can be overcome by the governmental body proving that it did not discuss any subject that was within the realm of the body's authority. One other thing to mention here is, let's say there is a chance that multiple members of a body might attend. Let's say there's a promotional ceremony for an employee, police officer, firefighter, just as examples. Then you may want to post a notice of possible quorum to get out ahead of it because it is a situation where you may have a quorum of the members of the body appear at that. And again, there's you can use a standard, kind of a standard form to post for notice of possible quorum, but you'll need to identify the event, the time, the location, and notify the public that it is possible that a quorum of the body may be attending the graduation on that particular day and time. Turning to notice requirements. So making sure that we comply with the notice requirements of the open meetings law. The key points here are that we have to provide advance public notice of each meeting, and we have to provide the public with notice of the business that we intend to discuss. Notice must be given at least 24 hours in advance, and only for good cause can notice be given up to 2 hours in advance. When we're talking about the 24 hours, it excludes Sundays and holidays from the timing calculations. Therefore, if you have a meeting on a Monday, chances are you need to post that on the Friday preceding that. Each meeting must have a separate and timely notice. I've got the language there concerning where the notice must be posted, how the notice must be given. The notice, what does it have to include? There's a number of things that it has to include: the time of the meeting, the date of the meeting, the place, and the subject matter of the meeting, including any closed session topics. And we'll talk more about what does that mean as far as identifying the subject matter. What specifically do we need to include there? It is a reasonableness standard when we're talking about how much notice or how much information must be provided. There are three factors that the Attorney General and courts consider here. The first is the burden of adding detail. The second is whether the subject is of public interest. And the third is whether it involves a novel topic as opposed to routine action. It's a case-by-case analysis here. It is best to err on the side of including more detail than less detail to be clear, specific, and transparent. Once reasonable notice has been given, meeting participants are free to discuss any aspect of the notice subject matter, as well as issues that are related to it. So as long as you have properly noticed the subject matter, you are free to discuss aspects related to that subject matter, as well as any issues that are reasonably related to it. However, a governmental body cannot address topics that are unrelated to the information contained in the notice. Now, a little bit more here where governmental bodies have run into some issues. Generic subject matter designations that are put on an open meetings notice are not, they're not sufficient. So just listing old business, listing new business without a further description of what old business you're going to talk about or what new business you're going to talk about generally is insufficient. Miscellaneous business, agenda revisions, things like that are not going to be sufficient. I have also seen things like council comments or for Police and Fire Commission, commissioner comments or commissioner questions without further description. That's generally not going to be sufficient. We have to advise the public regarding what subject matters are anticipated. Now, it would be appropriate, let's say, if a member of one of the departments presents on a topic that is included in the agenda, certainly a member of the body could ask a follow-up question on that same topic. So there doesn't need to be a separately identified topic in the notice for questions on a topic that's already included in the notice. But again, sometimes I've seen governmental bodies put a general or generic subject as council comments or something to that effect, and that's not going to be sufficient to advise the public on the topics that we anticipate coming up. The statute does not expressly require that the notice indicate whether action will be taken, so this is a key question that comes up a lot. However, if we know that action is contemplated in advance of the meeting, we should indicate in the notice that action is contemplated, again, so that the public is aware that action may take place. Now, you may not know in advance whether action is contemplated, and so in that situation, you could err on the side of including it. You could say discussion and possible action or something to that effect. A governmental body is not required to actually discuss every item contained in the notice. It is reasonable in appropriate circumstances to postpone items until a later date as well. So something to keep in mind, just because something is included on the agenda, perhaps you anticipated having a department report on a particular topic, but then you didn't receive the department report for whatever reason, you could postpone it until the next meeting or not talk about it that evening. Turning to open session requirements specifically. Open meetings, open session must be reasonably accessible to the public. We already talked about that a little bit, and we'll talk a little bit further about that here. You must convene an open session first. Then, if you are going to convene in closed session, you can do that, but you need to convene an open session first. As far as accessibility, the location should be public generally. Again, generally we should avoid having meetings in private places. Typically you're going to have your meetings at the location of the town hall or school district or whatever governmental body it is. To comply with the law, a governmental body conducting a meeting by telephone conference or video conference must provide the public with an effective means to monitor the conference. So if your body conducts meetings by Zoom, for example, then you would need to ensure that the link is available and accessible to members of the public who wish to observe the meeting. The Open Meetings Law grants citizens the right to attend and observe meetings of governmental bodies that are held in open session. The Open Meetings Law also allows citizens to record, film, or photograph open session meetings as long as they do not disrupt governmental business. So we have run into situations before where a reporter is recording a meeting and is not being disruptive, and a governmental body mistakenly believes that that recording is not permissible. That would be an error. It is permissible to record, photograph, etc., so long as the individual is not being significantly disruptive to the meeting. This is a question that comes up pretty frequently. There's no requirement to allow members of the body to speak, or excuse me, of the public to speak or actively participate in the body's meeting unless it's a public hearing, for example. However, a number of our governmental body clients do choose to have a public comment period. That is something that you can do, but it must be included in the meeting notice. During such a period, the governmental body may receive information from the public and may discuss any matter raised by the public. However, it is advisable to limit the discussion of that subject and to defer any extensive deliberation to a later meeting for which more specific notice can be given. So for example, if you have a member of the public who comes in, they make a comment about something and it's not included on your meeting notice, what I often advise is to thank the person for coming in for their comments and giving their comments, but advise that the body is unable to talk about it, given the fact that it's not included on the meeting notice. And then you can determine whether it is a subject that you wish to include on a future meeting notice. If it is a quick question, such as if they're asking who to contact regarding X, Y, or Z, that might be something that you could answer for them. But generally speaking, we don't want to go into an extensive discussion about a topic that was not included on the meeting notice. In addition, the body may not take formal action on a subject raised in the public comment period unless that subject is also identified in the meeting notice. So again, a number of our clients do choose to have the public comment period. That's something that has to be included on the notice. But again, we should be limiting the discussion of any subject that comes up unless it's included on your meeting notice. Okay, secret ballots. Secret ballots are not permitted except for officer elections, so we can't be voting in secret unless you're electing officers. We must create and preserve a record of all motions and roll call votes. This requirement applies to both open and closed sessions. That's a question that we do get is, are we required to take closed session minutes? Yes, if there was a motion or roll call vote that took place in closed session, we do need to make sure that we are recording that. Written minutes are the most common method used to comply with this requirement, but they are not the only permissible method. I would say that most governmental bodies do take written minutes to comply with that requirement. Nothing in the Open Meetings Law prohibits a body from making decisions by general consent without a formal note, but such informal procedures are typically only appropriate for routine procedural matters, such as approving minutes or adjourning the meeting. Turning to closed sessions. When can we have closed sessions? What requirements do we need to comply with? Closed sessions are limited, and we need to make sure that an exemption fits specifically with the subject matter that is being raised. We need to identify the specific exemption or exemptions that we are relying upon in the meeting notice. The notice provision in the statutes requires that if the chief presiding officer of a governmental body is aware that a closed session is contemplated at the time he or she gives public notice, the notice must contain the subject matter of the closed session. However, if the chief presiding officer is not aware of a contemplated closed session at the time of giving notice, that does not necessarily foreclose the governmental body from going into closed session under the statutes to discuss an item that's contained in the notice for the open session. So that's the key. If maybe you don't know in advance that a confidential matter related to an employee a specific individual employee is going to come up during the context of the meeting, You already have an open session agenda item relative to that. You still could go into closed session to talk about that individual employee matter, so long as the presiding officer announces prior to going into closed session the specific exemption that applies and indicates the subject matter that will be discussed in closed session. Generally speaking, we do want to include in advance everything that we're aware of that we intend to come up, during closed session. But again, if it's notice for open session, that does not prevent you from going into closed session. Before convening into closed session, the chief presiding officer needs to announce and record an open session, the nature of the business to be discussed, and the specific statutory exemption which is claimed to authorize the closed session. So this is important. A lot of times the chief presiding officer will just cite the statutory section, and that will be it. But that would be insufficient. We generally need to describe the specific exemption that we're relying upon. I recommend reading the language of the statutory section, along with identifying the specific subject matter that we intend to address during the closed session. And here it's really a careful balance because we don't want to disclose too much to the point where we are revealing things that would eliminate the need for the closed session in the first place. But we need to make sure that the public is adequately apprised of the topics that we intend to discuss during closed session. With respect to closed session minutes, so we talked about that. If action is taken in closed session, then that does need to be recorded. Most closed session minutes contain very little information other than to record motions and actions taken. So there isn't a requirement for the governmental body to take very detailed notes of the discussion that took place in closed session. The key is that we need to make sure we are keeping a record of any motions or actions that are taken in closed session. And we'll talk a little bit more later about that and when is it permissible to vote in closed session. Generally speaking, we need to vote in open session, but we'll talk more about that in the coming slides here. Some of the frequent exemptions that apply, and we'll talk about these, are quasi-judicial hearings, employment and personnel matters, and I kind of alluded to this. If you're talking about an individual employee, perhaps you're talking about whether to promote that individual. Maybe you're talking about potential disciplinary issues related to that employee. You might be under one of the exemptions for employment and personnel matters. Reputation or confidential information. We'll talk a little bit about that one. That is another one that our clients do cite to with respect to certain agenda items. Competitive or bargaining reasons is another one that our clients use. I have seen this, and we'll talk about this with respect to if you're looking at purchasing property, you're looking at selling property, and there are competitive or bargaining reasons to discuss the matter in closed session, then that exemption may be appropriate in that instance. And, it's really limited to when you're talking about that very specific negotiation strategy or bargaining strategy. Otherwise, the default is that we need to talk about that in open session. Legal counsel and litigation strategy is another one that our clients will use more commonly. And then there are a few as well that we don't see very often, and I'll just highlight those really briefly. Turning to judicial or quasi-judicial matters, I don't know how often you would have this as a town board. Where I have seen this is with police and fire commission matters. We have here on the slide, an example includes employment hearings, not zoning appeals. The situation must possess characteristics of a traditional judicial proceeding. So again, this is where the governmental body is acting in the capacity of kind of like a judge or jury. It's a quasi-judicial type hearing. There must be a case that is the subject of a quasi-judicial hearing or quasi-judicial proceeding before the body to fall under this provision for closed session. Employment and personnel matters. This exemption relates to dismissal, demotion, licensing, or discipline of any public employee or person licensed by a board or commission, or the investigation of charges against such person, or considering the grant or denial of tenure for a university faculty member. If a closed session for this purpose will include an evidentiary hearing or a final action, then the governmental body must give the public employee or licensee actual notice of that closed hearing and or closed final action. This is another one where I'm not sure if you use this one very often as a town board. Where I have seen this used as far as our school district clients is if it is a matter involving due process considerations for a teacher or an administrator, then this may be one where we are citing to this exemption. Wisconsin Statute 19.851C. This is one that you probably do use more regularly, again, in employment and personnel matters. This exemption applies when considering employment, promotion, compensation, or performance evaluation data of any public employee over which the governmental body has jurisdiction or exercises responsibility. It is sufficiently broad to authorize convening in closed session to interview and consider applicants for positions of employment. Other examples, evaluating a police chief's performance, setting or increasing compensation for specific employees. This exemption does not apply when we're considering general policy changes, when we're talking about compensation in general. This really focuses on individual employees. An elected official is not considered a public employee over which the governmental body has jurisdiction. So in that situation, this exemption would not apply. The purpose of this exemption is to protect individual employees from having their actions and abilities discussed in public, and to protect governmental bodies from potential lawsuits resulting from open discussion of sensitive information. So I do see that this exemption is commonly misused by governmental bodies when they're talking about general policy issues, general policy changes, and again, compensation in general. This exemption is not going to be appropriate for that. Sub 1F, another exemption relates to reputational or confidential information. You may use this one on occasion. This exemption covers financial, medical, or personal data where open discussion would cause reputational harm. The Attorney General has cautioned that this exemption is extremely limited. It applies only where a member of a governmental body has actual knowledge of information that will have a substantial adverse effect on the person mentioned or involved. It authorizes closure only for the duration of the discussions about that information. So where you might see this is when you're talking about medical information, for example, regarding an employee. Once you're done talking about that, then you need to go into open session. Again, the exemption only applies to when you're talking about that specific information that may cause reputational harm if discussed in open session. This exemption is not limited to public employees. As an example, interviewing a school board vacancy candidate where damaging information may surface. Let's say you're aware of something, there's scuttlebutt about it in the community. That may be something that you can discuss in closed session under this exemption. Once you're done discussing that information, you need to go into open session, and the vote must still occur in open session. Turning to sub 1E, competitive or bargaining reasons. This exemption applies when deliberating or negotiating the purchase of public property, the investment of public funds, other specified public business, and only if competitive or bargaining reasons require it. As I mentioned, this could apply when you're talking about negotiation strategies for collective bargaining. Maybe you're considering selling property or purchasing property, and you're talking about the specific terms that you would be willing to sell the property for. That is part of your negotiation strategy. The announcement of a contemplated closed session under this section that provides only a conclusory assertion that the subject will involve competitive or bargaining reasons is generally inadequate. So again, here we need to be careful with giving enough information to the public that they're aware of the reason why there are confidential or bargaining reasons that are going to come up, or competitive or bargaining reasons that are going to come up, without disclosing too much. In other words, to essentially avoid the need for having the closed session in the first instance. So what you might have here is consideration and discussion regarding terms of an offer to purchase, and then identify the property that's being considered. Then the public has enough information to know, okay, they're considering an offer that relates to this property, and they're going to be talking about the specific terms. So then we've given enough information to the public so that they know what the business is that we're going to be talking about and why there are competitive or bargaining reasons for why we need to talk about it in closed session. Mere inconvenience, delay, embarrassment, frustration, or even speculation regarding probability of success are not sufficient reasons to close the meeting under this exemption, or other exemptions for that matter, unless we're talking about a reputational issue related to a particular employee. And on this one, I mean, there is case law where a developer requested confidentiality, and that's not going to be sufficient just because the developer wants the public body to talk about the property in closed session. That's not going to justify it. There has to be a specific reason, competitive or bargaining reason, why we need to talk about it in closed session. Once we are done talking about those specific things that require the closed session, then we need to go back into open session. Now, on this one, I do get a number of questions on whether the body should or should not vote in closed session. If we're talking about an offer to purchase, for example, and let's say that you're still negotiating and you're providing your legal counsel or whomever will be negotiating the offer to purchase with the parameters within which the body would accept an offer to purchase. Those are things that can and should be discussed in closed session. However, if you've gotten through the terms of the offer to purchase, the body is ready to act upon that offer to purchase, then you should be going into open session to approve the offer to purchase. And that's just one example of where we can talk about things in closed session, but then should go into open session to approve of the final action with respect to that. And we'll talk a little bit more about this on a slide later, but if voting in open session would eliminate the reason why we were in closed session in the first place, in other words, it would reveal our confidential negotiation strategies, if it would reveal the terms within which we would agree to accept an offer to purchase, then those are reasons to vote in closed session. But otherwise, we should be voting in open session. That is the default, and goes along with the public, the transparency things that we talked about at the beginning. Legal counsel and litigation strategy. This is another one that our clients do use with some frequency. A closed session is permitted if the governmental body's legal counsel is rendering advice on strategy to adopt for litigation in which the governmental body is or is likely to become involved. There is no bright line rule on what likely litigation means. Generally speaking, governmental body needs to obtain legal advice on whether it is or is likely to become involved in litigation, and whether this is an exemption that the governmental body can rely upon. If someone has threatened to sue the governmental body, or if someone has submitted a notice of claim, then that's a closer call that okay, there's likely a claim coming. We've gotten notice of the claim, or this individual has sent us a demand letter. They're claiming that they're going to sue us down the road. Then it's likely we can rely upon this exemption. The presence of the governmental body's legal counsel alone is not in and of itself sufficient reason to authorize this exemption and to authorize closure of the meeting. Again, the way that this exemption is written, it focuses on litigation in which the governmental body is or is likely to become involved. Now, that doesn't mean you can't rely upon other exemptions. For example, you might be talking about a specific individual employee matter that would fall under a different exemption, and certainly you could have legal counsel in the room during the closed session in order to receive legal advice regarding that topic. Similarly, I advise clients frequently, public bodies, with respect to property issues, selling property, buying property, and they may be in closed session under the previous exemption that we talked about under 1E. And although I'm not advising them on litigation, I still will be in closed session with them to advise them concerning the terms and conditions of the offer, talk about negotiation strategies, parameters, things of that nature. Here are some other exemptions under the open meetings law. Unlikely that you're going to have these come up, pretty uncommon for certain bodies, but nevertheless wanted to mention them. All right, a little bit more on closed sessions. A governmental body has wide discretion to admit into closed session anyone whose presence the body determines is necessary. It is based upon a majority decision. So let's say there's disagreement among members of the board on whether to bring in a particular person into closed session. It is going to be based upon a majority decision. So just because one person wants to invite someone into the closed session doesn't mean that that person gets to attend. It is up to the body by majority decision as far as who is invited to come into closed session. Certainly any member of the body would be involved in the closed session. But if you have, let's say, a department head, an employee who you want to ask questions of, legal counsel, let's say you have your accountant or an engineer or someone like that who you're considering having come into closed session, then that is a decision that the body needs to make as to whether they wish for that person to come into closed session. And also how long that person remains in closed session. So you could have them come in, they answer your questions, and then we politely ask them to leave so we can continue talking about governmental business during the closed session, so long as the exemption still applies to what we're talking about. As I mentioned, if we've gotten past the competitive or bargaining reasons or the reputational concerns, then we need to go back into open session to finish the discussion on that topic. If the governmental body is a subunit of a parent body, the subunit must allow members of the parent body to attend its open session and closed session unless the rules of the parent body or the subunit provide otherwise. A governmental body should vote in open session unless doing so would compromise the need for the closed session. So we talked about this. Again, no bright line rule per se, but you should definitely err on the side of voting in open session. There are only limited circumstances where voting in closed session would be permissible. And I gave an example of that where if you've determined what parameters you're willing to negotiate for purchase of property, for example, and if we were to go into open session and talk about that and vote on that, and that would reveal our negotiation strategy, in other words, it would eliminate the need for having discussed it in closed session in the first instance, that may be a reason to vote in closed session. A body may reconvene in open session after closed session if public notice of the open session was given at the same time and manner as the original notice. If a time is specified in the notice, the body must wait until that time to reconvene. If immediate reconvening is planned, no time needs to be listed on the notice. So what I usually advise clients to do is to have in their notice that reconvene in open session following the closed session to consider and act upon matters that were discussed in closed session if appropriate. So then the public knows that after the closed session, we're going to immediately reconvene in open session, and we may take action if appropriate regarding the items that we discussed in closed session. Again, if you include a specific time, that really does limit you because then you have to wait until you get to that time before you can reconvene an open session. Otherwise, we've told the public something inconsistent. After the closed session is finished, the presiding officer must make sure that the door is opened and announce to the public, anyone who is waiting in the hallway, that the session is now reopened. Turning to enforcement and consequences, both the Attorney General and district attorneys in Wisconsin have the authority to enforce the open meetings law. A district attorney has authority to enforce the open meetings law only after an individual files a verified open meetings law complaint. Proceedings to enforce the open meetings law are civil actions, not criminal actions, so a little bit different than what you would see in a criminal case. The rules of civil procedure apply to proceedings to enforce the open meetings law. If the district attorney refuses to commence an open meetings law enforcement action or does not take action within 20 days after receiving a complaint, the individual who filed the complaint may bring an action in the name of the state to enforce the open meetings law. However, the district attorney is not prevented from bringing an action, even though 20 days have passed, so they can still do that. And generally speaking, it's not uncommon for that review and investigation by the district attorney to take longer than 20 days. District attorneys in the state are often quite busy with caseloads, and it is possible that it may take longer than 20 days to conduct that review. So the individual who filed the verified complaint may proceed to enforce the open meetings law violation, or the district attorney could still take it up after the 20 days has passed. They're not prevented from doing that. Any member of a governmental body who knowingly attends a meeting held in violation of the open meetings law or otherwise violates the law is subject to a forfeiture of between 25 and 300 for each violation. Knowingly means positive knowledge of the illegality of a meeting, but it also means awareness of the high probability of the meeting's illegality or conscious avoidance of awareness of the illegality. However, knowledge is not required to impose forfeitures on an individual.
Oh, honey, you can go in. Oh my God, yeah, after Leah left, you could go in.
Knowledge is not required to impose forfeitures on an individual for violating the open meetings law by means other than attending a meeting held in violation of the law. Some examples of other violations are failing to give the required public notice of a meeting or failing to follow the procedure for closing a session. Some possible defenses to an enforcement action are the member made or voted in favor of a motion to prevent the violation. So if you are a member of a body and you recognize that something may be taking place that you think may not be in compliance with the law, you may avoid a violation by voting in favor of a motion to prevent the violation, abstaining from participating in the motion. Potentially could be enough. However, it would be best for you to vote against it to make it clear that you disagree with the motion. Members' votes on all relevant motions prior to the violation were inconsistent with the cause of the violation. That would be another potential defense. Another potential defense is that the individual did not act in their official capacity. And then lastly, that the individual relied upon legal advice. So if there is legal counsel who is in attendance at a particular meeting and the legal counsel offers advice that they think it would not be a violation of the open meetings law, then that may be a defense if you rely in good faith upon that legal advice. Another comment that I wanted to make here is that we're not talking about Robert's rules today. We're talking about the open meetings law. So we do have a lot of governmental body clients who follow the Robert's Rules of Order. Some follow it more closely than others. So I just wanted to make that point that Robert's Rules is a totally different presentation for another day. Open meetings law is it's statutory. You all have an obligation to comply with the Wisconsin open meetings law. Robert's rules are rules of procedure and are a little bit different or very different, I should say, than the Wisconsin open meetings law. So we've concluded a little bit early, so we do have some time for some questions, if there are any from members of the body.
Can you hear me?
Yes.
So general question relative to this PowerPoint presentation. If there's any questions while we're digesting what we just saw, do we submit those questions to the town clerk and she submits to you for answers?
I think it would be best to submit them to the town's legal counsel. It's my understanding the town has an attorney who regularly advises the town.
That's correct, yes, and he is here.
And the other half of that would be if there is a response or a reply to the question, will everybody in this room benefit from that who's present in this room right now, who needs to abide by this presentation? Will they get the answers also that maybe one member of this audience would ask?
I think, that would be a question for the town's legal counsel in terms of, if it is a sort of a general answer regarding what is the law versus whether it's, legal advice, that might be subject to attorney-client privilege. But the town's legal counsel should be able to tell you that with respect to the specific question that's being asked.
Yeah, the other one is there relative to the DA reviewing a complaint, they have 20 days as stated on your slide. But you said they could go over that. Is there a statute of limitations relative to that? Meaning if they go over 20 days, is there a limit that says, okay, 6 months has passed, this is thrown out?
I believe there is, however, I apologize, I don't have that number in front of me today, so I'm unable to answer that question. Again, the town's legal counsel might have that information.
And then the other question I have is, this goes back to the beginning of the presentation relative to texting and emailing, etc.
Yes.
Can you provide some examples of more examples of do's and don'ts or allow or not allowable relative to texts and emails?
Yeah, so if it looks like the body is engaging in governmental business and if you're exchanging text messages and emails kind of in rapid format and it's about a governmental business item and suddenly you have multiple people who are in the body, the governmental body, weighing in on a particular topic and they're doing so in a manner that is kind of like instant messaging, if you will. So you've kind of come to an agreement outside of the context of a governmental meeting, then that may run afoul of the open meetings law. So generally speaking, I mean, I advise our governmental body clients not to be exchanging, multiple emails on topics, text messages on governmental business. Those are the things that should be properly noticed and discussed during the context of an open meeting. Again, one-way communication is generally not going to be a problem. So oftentimes what I do is I will send an email to my governmental body client and the body's members, and I will have them blind copied so I don't run into issues with reply all. I know that some of our governmental body clients do that as well. If the board president is going to be sending out something on a particular, maybe it's to provide an update concerning something, to do it in a way that it doesn't create a reply all where you have rapid responses from multiple members of the body on an item of governmental business, and then it looks like a decision has been made outside of the context of a noticed meeting. So I hope that helps.
Does that apply to a one-on-one correspondence? Back and forth, one-on-one? Or if you get into a quorum situation?
Yeah, I mean, I think the issue is whether it's a negative quorum. In other words, does it involve enough people that it could invalidate a particular action? So I would say it all depends upon the number of people who are involved in the communication and the number of members of the body and what constitutes a quorum of the body. Because we don't want a situation where enough people have communicated with each other that we've now created a negative quorum.
So here's an example. Can I email or text a member one-on-one? And not as a group, but go to another member and text relative to the same topic and get a response from them one-on-one.
I would say no. That is kind of like polling, if you will, the members of the body on what their thoughts might be on a particular governmental business item. If you're talking about going out for coffee or something, that's not a problem. But I assume you're asking about a particular item of governmental business, and generally, it's not appropriate to poll the members of the body like that. So when I'm talking about one-way communication, I'm talking about, more of like a status update that's being provided. Not that there's back and forth taking place on a particular item of governmental business.
Well, I have a question. Going back to the meeting notice guidance that you provided, and specifically the meeting location and providing that within the notice. Are there any legal requirements with respect to the need to provide online or virtual meeting channels for public participation in meetings? Or is that more of a discretionary item and the presumptive attendance channel is being physically present at the meeting location in the meeting room?
Yeah, I would say that if the meeting is noticed to take place in person and the members of the body are anticipated to attend in person, so it's not a situation where you have an empty room and then everybody appears virtually and maybe you have a screen somewhere. But again, if everybody is anticipated to appear in person, the default is that they're going to appear in person, but maybe you have one member of the body who is traveling at the time and they call in or they appear virtually pursuant to the rules of the body. You don't need to make arrangements for a member of the public to also appear virtually or to call in for something like that.
Okay, so just understanding that if the members of the body are going to be physically present in person, there's no need to provide a virtual channel. If you provide a virtual channel to the public, it's a courtesy or it's an extra participation channel, but it's not required. Is that correct?
Right. There's no requirement for us to have two methods for members of the public to be able to observe the governmental body or, to participate. But yes, you could do it as a courtesy. And as far as public comment goes, that's another question is if, as a courtesy, do you allow someone to appear virtually and then also to speak virtually? So those would be decisions that the governmental body would need to take a look at. But yeah, no requirement to have two different methods. However, if you've got the majority of the body appearing virtually or by telephone, then I would say you need to provide that method to the public to be able to observe the governmental business that's taking place, but it sounds like what you're talking about is more, it's in person, the default is in person, but we're looking at whether, as a courtesy, do we also have to have a virtual option? I would say it's not a requirement, but you could do that as a courtesy.
Okay, no, that makes sense. Thank you. And it was really both perspectives. I mean, if it makes sense that if any members of the governmental body are attending virtually, that the public can attend virtually. Not a big deal, no problem. But if everyone's going to be there in person and you still provide a virtual channel, that's a courtesy to the public. It's not a requirement.
Right.
Got it. Thank you.
All right, well, I will make a motion to adjourn. Well, I will not make a motion. I will say, let's call for adjournment here. Board members, please, somebody make a motion to adjourn. Looking for a second? A second, the manager, all in favor?
Aye.
Jenna, thank you for your presentation. We appreciate it.
Appreciate it.
Thank you.
Bye.
Thank you, everybody, for coming. Appreciate it.
Thank you for putting it together.
Thanks, Jenna.